Hello everyone, welcome to Chapter 9, the medical record. Of course, this is pretty self-explanatory with some of the stuff that we're going to be going over. I'm sure many of you have heard it 1,000 times. HIPAA, all that kind of good stuff in regards to privacy, very important in relation to the medical record in Chapter 9. So feel free to take a look at the learning objectives when you get a chance, but some of the things in here are of course gone over in the PowerPoint. So the medical record is also called the health record. So it has all the case documentation and history, current diagnosis and treatment, correspondence to patients inside that living document. Of course, electronic most of the time now. There's still some paper health records out there. However, there's some regulations behind that. It's a legal document. It can be subpoenaed in court at the behest, of course, of the judge and attorneys and such. So the purpose of the medical record is to record a patient from birth to death, document continual management of patient's care, provide data and statistics for people making informed decisions on the healthcare of individuals or communities, and then track ongoing patterns in a person's health. So, maybe you're on blood thinner as an example, and it has a one impact now, and it could have another impact down the road, and that's just one of the many examples of how health records used. Come into the emergency room with an inability to communicate. If you have an active health record and they can determine who you are, there's a lot of safety mechanisms there to make sure that you're getting the proper care and not going to have an adverse reaction based on maybe drugs that you're taking or potentially things you're allergic to. So some contents in the medical record, just kind of common sense stuff here. Prescriptions, lab reports, x-rays, medical examinations, etc. Some more contents of the medical record are located here. Diagnosis, complications, consent forms, consultation reports, health professional notes, etc., etc. All right. There's a lot of slides, so I'm going to go pretty quickly. So you can correct your health record if there's an issue. Nothing's usually deleted. Most of the time it's crossed out and there's a note next to it in ink, or they do this digitally. Now, of course, with electronic health records, they'll make a note and fix it. And that happens quite often because people make mistakes. Providers can make mistakes, and patients have the right to correct their health record based on falsification of or mistakes. Falsification of medical records ground for criminal indictment. So if you put something in there that's, of course, wrong, you're going to be held accountable for that if it's caught. All right. Thing that always comes up, especially in healthcare practices, is timeliness of documentation. Certain entities, certain organizations have requirements for how quickly the provider has to document on the case in the health record. Usually it's within 30 days, but some are as soon as 3 days. I've seen some policies, range from 1 to 3 days, but most of the time it's around 2 weeks. So it's a requirement to be completed. You can't bill for patient care unless you finish your documentation, of course. Yeah, this is kind of common sense. We've talked about this before, just in regards to medical records. If it's not documented, it wasn't done. So you have to document in order to have credibility there. Credibility is another thing that we talked through. There can be credibility gaps. Some problems, when we were writing and had written health records, not electronic, illegible handwriting could have been an issue. Delays in placing tests, potentially, and then any invented documentation, so any extra documentation that really wasn't a part of the patient's healthcare journey. So this is a really complicated question. A lot of people ask me, who owns the health records? Patients have a right to privileged communication in a health record. They do not own the health record. They don't own their health record if it's generated in a facility. Usually the facility does, or the owners of the healthcare facility. So a lot of people have asked me that over the years. The patient does not own their health record, but they do have access and a right to it. Patients also have a right to release or not release their health record in writing. So not anyone can go up and get, of course, a copy of your medical record. It has to be released by the patient, and it has to be done based on professional discretion. And physicians can determine, based on their best judgment, if a patient should view their medical record. It can be locked down, and a lot of times this is due to mental health concerns or concerns of potentially harming themselves or others. All right, heavy topic here, confidentiality. The thing that HIPAA really controlled is releasing medical records without consent. Of course, insurance companies can't do this, healthcare companies can't do this. There's regulations behind that. And then only specific records requested should be copied and sent. That's kind of common sense. You can't take photos or visual images without patient consent because it's an invasion of privacy. Release of information, we talked about that. You don't send the entire medical record. It's going to be a section of the medical record. Only a patient can authorize his or her own medical records release. There are some states that have freedom of information laws that grant public access to records maintained by state agencies, but medical records are exempt from this statute. All right. So alcohol and drug abuse patient records, there's some protections there. You can read through this. Of course, there's exemptions too if a patient needs emergency care, but there are protections to not release that type of information. And then storage of medical records. Legally, records must be stored for a minimum of 10 years since the entry. If it's online, that's a lot easier because there's a purge in the system usually at the 10-year mark, and a lot of this stuff is stored in the cloud and secure, of course, in secure domain. So it really was more of an issue when there was paper records versus electronic health records. This is talking about paper records, but usually kept within a physician office, locked up, of course. It can be stored in a storage unit as an example. It's got to be secure though. This talks a little bit about the security of electronic health records, passwords, encryptions, firewalls. This is not something that, of course, each healthcare system has on its own. They usually contract with a large electronic health record company. Epic's a big one. Cerner's another big one, and these are major companies that work really hard to make sure that these sets of data are protected, and they do a pretty good job of it. Now, hackers have gotten into certain electronic health record systems before, but some of these major companies make it very, very difficult for that to happen. So personal health record is a record of information often in the patient's own words. It's controlled by the patient's family. Something to keep in mind. It provides family members and caregivers accurate information in caring for a patient and making decisions for further medical care. That's your personal health record. It's not a test question, but something to keep in mind. And then loss of medical records. That happens at time, of course. There can be issues. Maybe they're deleted on accident. Maybe there's a duplicate record with the same name that's accidentally deleted. I've seen that happen before. But sometimes they can be backed up in the system, so you can get it from electronic servicing company, or when it comes to paper, that's going to be more of a challenge. But from that perspective, that's one of the reasons why electronic health records are so much safer. There are some reporting disclosure requirements. The flu is one of them, and some of these other, COVID was one when that came out. So if a patient has these, a disease or something that's going to impact the community, there are some reporting requirements state by state. So just keep that in mind. And most of the time they don't ask for a patient's name there. It's just kind of general information. And then use of medical records in courts cases. This happens. Subpoenas, of course, can happen in regards to medical records. And then you got to be careful for improper disclosure. Healthcare providers and institutions can face civil and criminal liability for releasing medical records without proper patient authorization. The subpoena process can be complicated. That's why there's usually attorneys on staff or people in medical records to help facilitate this process. So we went through that pretty quickly. 26 slides. I know you have a supplemental lecture as well, so be sure to take a look at that. And of course, if you have any questions, it's a pretty short chapter, but a lot of great information here. Reach out anytime. I'm happy to help. Thanks so much.